Hello again, everyone. It's Rob Ryder on Sunday, December 29th, 2019. One last video for the year. And today, it's on ADR, which is Alternative Dispute Resolution, for U.S. service and veterans issues, real estate, and, possibly very, very many more things. But you have to start somewhere. So the idea then is alternative dispute resolutions, ADR, of contract defaults. And there is an act called the Equal Access to Justice Act that allows individuals, small businesses, and public interest groups to obtain representation in cases against the federal government and not be held to attorney fees in the event that they are successful. AKA, in other words, they're going to pay the attorney fees. And so it's all set up under this Equal Access to Justice Act. And I think it's $125 an hour that they can charge or something. It's all built in. So, if you had a dispute and you gave it to an attorney and he can see that you were right and it's against the federal government, then he can be paid by the government for presenting your case. It's a win-win for everybody. So notice, enlisted veterans are victims of enlistment contract default. We have never been released from the custody and control of, in my case, the Army. Right? You've never received a separation order that administratively separated you from the custody and control of the branch of service that you were in. Therefore, you are still in, and because of that, you're still under your enlistment contract. And your enlistment contract says that you're due pay, privileges, and benefits that you're not getting from the military because they're acting like you're not in the military anymore. So apparently there's a dispute to be resolved, and that's one of the disputes I'm going to try to get fixed. That our issue isn't so much with the VA, although there is an issue there. The issue is with the branch of service you're in because they never released you and they haven't given you the benefits you should have gotten or should be getting for not being released. Quite interesting to think about. Real estate transactions have ADR terms and conditions. So things like title insurance policies, purchase agreements. They all have something built into the boilerplate conditions that talk about use of alternative dispute resolution. And real estate financial transactions involve federal agencies, such as Freddie and Fannie and HUD and FDIC, Department of Agriculture, and so forth. And so, what you'll find out is that if you look at your loan paperwork, that nobody ever lent you any money, right? Because the bank never signed the paperwork. And on your title insurance policy, the title insurance policy isn't in your name. It's insuring a thing, but it's not insuring a living natural person like it's supposed to by its own terms and conditions. Now, the problem with title insurance is you didn't get the owner's title insurance policy. The seller got you as the buyer of the owner's policy, so it's the seller's fault that it has the wrong name on it. But the seller was represented by a seller's agent who's responsible for the actions of the seller, so now it's the seller's agent that's responsible. But that seller's agent isn't responsible to you, he's responsible to the seller. So you have a buyer's agent who is responsible to you, who was working with the seller's agent, who was supposed to act as the seller and get this title insurance policy in your name as the buyer, which they didn't do, from the title insurance company. All right, so you got this little roundy round of people that have all done something incorrectly, and it's resulted in the fact that you don't have title insurance on your property, and you never paid, they never signed any contract to lend you any money. And this is all just a fictional system that we're put under where, somebody's using the fact that we don't know this to our disadvantage. So, because the federal government's involved, then you could take them to ADR because the Administrative Dispute Resolution Act of 1966, Public Law 104-320, Make the United States, basically by that, you make the United States respondent to an ADR proceeding, and your attorney can claim his pay from the government if he successfully settles your claim. Or you can contact a neutral, which is talked about in this act here. And basically, if you look at what they can do, they can issue summary judgments. And so the Alternative Dispute Resolution Act goes beyond the UCC and Title V. When you read the act, they're saying, look, that got to be too cumbersome. We need something simpler. And they are now, in this act, talking about these people called neutrals, which is basically, some federal employee of a different agency acting as the go-between or the neutral, right? Impartial witness, basically, looking at the dispute, deciding who's right. Now, it goes on to say that all the agencies have to set up some kind of system to do this, right? Some ADR system. And, sure enough, you look at your branch of the service, they're going to have an ADR, Alternative Dispute Resolution, system in it, or any of these other agencies. They're all supposed to have an ADR process in place or policy in place. Okay, so anyways, before we get to all the good stuff, my email address is courtofrecord@aol.com. Oops. And phone number is 616-712-6179. I ask if you could, please donate. Call it charity, pay it forward, and send it to my PayPal account, robryder@aol.com, or to my mailing address of Robert Allen Rutluski, 10955 14 Mile Road Northeast, Rockford, Michigan 49341. Because while I'm really working to get a remedy that everybody could use, I haven't found one yet. And, somebody has to do this work, and I work for almost nothing. I just need to have a few bills paid so that I can continue to, read the things that need to be read and try the different avenues that other people aren't trying. I know other people have their own ideas, and that's good. I mean, go ahead and do them, but, they don't fit what I've read, and what I read is what I'm showing you. And so you can agree with the things that I'm showing you or not, but don't blame me. They said it. I'm just repeating it. But if they said it, I'm going to try to make them use it. So that's the idea, right? I'm not taking no for an answer when I can read the law and it says yes. I'll just find somebody else to take it to. Okay, so before we get into this, I got to stop and load up a few papers, and we're going to look at a title insurance situation first. So hang on here. Okay, so I'm going to take you on an adventure from the, title, or from the foreclosure hearings in a court back to the beginning, which would be, when you were buying the property in the first place, to find out, well, where did the thing happen that is causing you to be in court right now, and the title insurance company not being there and defending your title? Because that's their job, is to defend your title in legal actions. So there should be, if you're being foreclosed on, there should be a title insurance attorney there with you. But there isn't. So in my last video, it was called Arbitration Rules the Nation. I was showing this couple of cases that I can't get into all the detail again of what they were, but that's where you'd find more information on them. So you have to look at that maybe. And because I'm looking at this now, this video on Donald John Trump in 3 U.S.C. 19 shows that Donald John Trump hasn't taken the 2 oaths of office that he needs to be the president, and so the office is vacant. But there's nobody in Congress or the vice president. There's nobody who can take his place because none of them have a proper oath of office either. All that's in this video. And I'm asking if you have any way to get this to somebody like Alex Jones, Rush Limbaugh, somebody to have them look at it. Because it's, it's really, really basic. You look at it and say, well, duh, they didn't take the right oath of office. They don't have any. The Congress doesn't have any authority. Right? They took an oath of office that says, so help me God. Well, that violates the 6th article of the Constitution. So I've been pushing this off through all sorts of means, and now I'm doing it by verbally asking you to see if you can get it in somebody's hands. If you know somebody high up in the military, you know somebody high up in the government, somebody say, hey, you need to watch this video. In other words, make it go viral. It's only got 3.7K views. That's terrible. That's about what mine seemed to go, because there's not that many people that want to think this deeply, right? They want the 20-second soundbite answer, and I'm afraid I can't give it to them. So let's start here. Let's look. There's this thing called the EAJA, right? The Equal Access to Justice Act, the federal law enacted in 1980 to allow individuals, small businesses, public interest groups to obtain representation in cases against the federal government and not be held to attorney fees in the event that they are successful. And it goes on to say judicial and administrative cases, right? So it's not just judicial court, it's an administrative hearing. And so if you're doing your own, you can still charge them. If your case is against the federal government and you win, then you are entitled to attorney fees. Now, whether you take them for yourself or you tell an attorney, look, if you win, there's your fee, and he just submits the papers you need to put into ADR to get the answer, well, then that's good too. So, Equal Access to Justice Act. Okay, so this court case here, I showed in the video that, right in this Arbitration Act, this is Jackie's case down in Florida. And, the plaintiff is the United States of America. Well, there you go. So the United States is now a defendant. Because we're going to say, well, this is a civil action, and in Florida, any contested civil action can be sent to non-binding arbitration by the court. And so we applied for application for arbitration, and they put it in. Right? That just happened late last. Well, this shows on the 20th, which is when they got it, but they didn't really do anything until after the holidays or after Christmas, and then they put it in, right? And then they backdated it. So the application's in. And we'll see what they have to say to the application for arbitration. And at the time, I wasn't even, thinking about the Equal Access to Justice Act, but it's plain to see. Well, the United States is now a respondent in the, because now you're back to parties. You're not plaintiff and defendant. Now you're parties. That's how it would be in the arbitration or mediation or whatever it is. And so, anyways, this is her case going on right now where we've asked for arbitration. Now, part of that was having her, Jackie went and found her title insurance policy. Where in the heck is that at? There it is. All right, so here's her owner's policy. American Land Title Association policy number, policy number, right? SDC, no zeros, just some numbers. There's no space there to put in any zeros. That'll make sense in a minute. What it's about, signed and sealed and delivered, because she has a copy. And then the Schedule A, right? This is, what's being insured. This is the insured. Well, this isn't how she spells her name, Jacqueline, and it doesn't have her middle name, and it has a comma, a single person. Well, this insured is supposed to be a natural person, right? So it should only have your full legal name. Jacqueline Victoria Veazey, with Jacqueline spelled right. She doesn't have an E between the C and the Q in her name, right? But this name almost looks like the name that's on the title insurance, or on the warranty deed, but the one on the warranty deed doesn't have this E either, right? But they've insured a thing. They didn't insure a living person who should be insured under this policy. Now, according to something I'll show you in a little bit, this owner's policy comes from the seller. It doesn't come from you don't go buy your own, right? So you can't go to them directly and say, hey, fix this for me. Because, you're not the one that bought it. The one that bought it is the seller. And if he says that's the name of the insured, then that's the name of the insured. This is where, now you got to go back against the seller. to get this thing fixed. But the seller was working through a broker, and the broker isn't working for you, so they don't have to answer. But you had, as the buyer, you had a broker. And that broker has a fiduciary duty to you. And they have this ADR in the real estate transaction. So I don't know how far we have to go back to get somebody involved in this to get it fixed, but that's the problem with your title insurance. It doesn't have your name on it, but you didn't buy it. Somebody else bought it for you. But it's wrong, right? And then this is the legal description. But in the policy, it says, down here, 14, right, unless prohibited by applicable law, arbitration pursuant to title insurance arbitration rules of the American Arbitration Association may be demanded if agreed by both the company and the insured. Arbitratable matters may include, but are not limited to, any controversy or claim between the company and the insured arising out or relating to this policy. Right? Well, who's the insured? Right? It's not Jackie in her full legal name, so they're not talking about her. This is the problem, is that they don't have you as the insured, and you need to get yourself as the insured. So to do it, you may have to go to arbitration. Okay, so it's written in the contract. That's really all I wanted to show on that. And so we had written to them. Jackie did, and it was based on. She has Old Republic, right? Old Republic title. You go to their website and you can submit a claim by email, right? Submit a claim. You can do it by mail. You can do it by email. You do it by email, you got to pick your state, use this email address. So she used Florida's. Well, she gets a letter back then, right, that here's her claim number, here's her policy number, but this has got zeros in it. The other one didn't. Right? Now her name doesn't have an E in it, and the address is a street address. Right? It's not the address. It's on the Schedule A. So yeah, they're deceitful. Right? They're going to try to weasel out everything. You have to look at every line every time, because they're born to lie. These people lie, cheat, and steal. Right? That's how God said you would know them. You know them by their works. Well, their works are always evil, because they lie, cheat, and steal. They're going to do everything they can not to pay this claim by making up a story that, okay, we're going to give it to, this is your policy number, which doesn't exist, and this is the name of the insured, which isn't, doesn't exist, and this is the address, which doesn't exist. That may be the street address, but it isn't what was insured on the Schedule A. This was insured. Right? This is like a parcel, a plat map description, where this is a street address, right? And now, hey, if you got any more questions, send it to this address, right? Don't send it to the one we said. Send your stuff to this one, right? Now, so they're trying to take you away from this email address to act like it's a claim by somebody who doesn't exist for property that doesn't exist, and so forth and so on. And, well, so be it. They can be called to this arbitration. If we can get the court to order arbitration, well, then we can call the title insurance company, because your arbitrator could subpoena people. And where did it? So here we go. So in the Florida, page 9. This is here. 2018 ADR Resource Handbook, Florida Dispute Resolution Center. I mean, even if you're not from Florida, right, you may want to download this and read it, because it gives a pretty basic description of places to get started. And I'm not trying to be an expert on all this. I just want to get the first part done. Let it go from there. But you got to get the very first step done properly, or you're never going to get any relief. And it says, court-ordered mediation, right? Upon request of one party, refer mediation of any civil action for monetary damages providing the requesting party is willing and able to pay for costs. Well, then we can't use mediation because this isn't for monetary damages. They're going to take her property. So, it's for money, that's true, but they're also taking her property. So you can't mediate it. Right? And then it says, unless, then it gives all these reasons you can't. And one is the action is filed for the purpose of collecting a debt. And if you look at paperwork in a foreclosure case from the opposing party, it always says on the bottom, it's, the intention is to get information for collecting a debt. So you can't mediate it. But you might be able to get court-ordered non-binding arbitration. A court pursuant to rules of the Supreme Court may refer any contested civil action filed in the circuit or county court to non-binding arbitration. Perfect. That's all we want them to do. Right? You got to contest the civil action because civil actions really aren't supposed to be contested. It's supposed to be an agreed-to contract of some kind, and that's what you're going to this contract court for. And you need to contest it and make it adversarial. Because they're acting like when you first go to court, it's a non-adversarial proceeding. And if you want it to be adversarial, you need to speak up and say, I want this to go to non-binding arbitration. And by doing so, you're just saying, hey, I'm contesting this, and, send it to arbitration. Right? Any party to arbitration may petition the court in underlying action for good cause shown to authorize the arbitrator to issue subpoenas for the attendance of witnesses and production of books, records, documents, and other evidence at the arbitration, and may petition the court for orders compelling such attendance. That'd be a subpoena, right? Order to show cause, and production at the arbitration. Subpoena shall be served and shall be enforced in the manner provided by law. Well, a proper subpoena is an action coming out of a court of chancery in equity. Right? It's a proceeding in a court of chancery. So this has gotten you into the court of chancery by going to arbitration. Which makes sense because the court of chancery is supposed to be run by the church. It's like you're going to the church first before you go to the court. Right? Christians shouldn't be going to court. We should be going to the church. Well, how do you go to the church? You go to arbitration. That's how you go to the church. This guy is the confessor. Right? He's the court chaplain. Maybe we can get it taken care of without having to have a judicial proceeding, right? This is all non-judicial. And it goes on and on and on. And, well, I don't need to know any more now to ask for it, right? So that's what we did. And we'll see what they come back with from the court. Hey, since we're here, this is that Administrative Dispute Resolution Act of 1996. All right, that said administrative procedure embodied in Chapter 5 of Title 5, United States Code, right, which would be the UCC. And other statutes is intended to offer a prompt, expert, and inexpensive means of resolving disputes as alternative to litigation in federal courts. Right? But these proceedings have become increasingly formal, costly, and lengthy, resulting in unnecessary expenditures of time, yada, yada, yada. So, hey, it isn't working. Right? UCC isn't working. They're telling you in the first two frickin' sentences or paragraphs of this Section 2. We need something else. The availability of a wide range of dispute resolution procedures and increased understanding of the most effective use of such procedures will enhance the operation of the government and better serve the public. We're going to go do something different. Promotion of alternative means of dispute resolution. Alternative dispute resolution under Chapter 4 of Chapter 5 of such title. What title was that? 5 U.S.C., right? So go look at 5 U.S.C. subchapter 4 of Chapter 5. Jeepers. And you find all these different choices. Right? And one of the things they're going to do is have a dispute resolution specialist. The head of each agency shall designate a senior official to be the dispute resolution specialist of the agency. Well, I believe they've done that. All right, so if we go, hang on now, all the way down here. Office of the Army General Counsel. General Counsel of the U.S. Army. That's good to read. The General Counsel is the chief lawyer of the Army, ultimately responsible for determining the Army's position on any legal issue. Well, hey, that would include this right here, Donald John Trump in 3 U.S.C. 19, because not only is Donald John Trump the president, he's supposed to be the commander-in-chief. So I think the General Counsel of the Army would have something to do with making sure that the commander-in-chief's paperwork is squared away. Or they would be defaulting on their contract. But regardless of that, ADR is ADR, and they have one, right? And they had a director appointed because that's what they were told to do. And, so they have a program. Okay, well, good. Because I'm going to tell the Army when we get to that spot that, well, you've defaulted on my enlistment contract. I want to take it to alternative dispute resolution, please. I don't want to sue the Army. I just want them to agree, hey, I'm still in. Okay, well, then pay me. Because they will, right? Once the agreement's made, they'll give it to you. They'll sign the contract. You have a contract. If you were still in the Army and your pay was screwed up, it would be a big deal. They would get that stuff figured out while your pay was screwed up. All right, so you are still in the Army, so it is a big deal. Don't let them tell them you're not, because until they can produce the order that administratively separated you from the command and control of or custody and control of your branch of service, you're still in. Okay, I need another second. Hang on. All right, we'll get back to the real estate in just a second. But continuing on in this act, you get down here in this section 573 talks about neutrals. And that's where, it gets interesting because a neutral may be a permanent or temporary officer or employee of the federal government or any other individual who is acceptable to the parties to a dispute resolution proceeding. A neutral shall have no official, financial, or personal conflict of interest with respect to the issue in controversy unless such interest is fully disclosed in writing to all parties that da-da-da-da. The president, a neutral who serves as a conciliator, facilitator, or mediator, serves at the will of the parties. I have to, I ponder this a minute because I heard a guy say one time that they were in court and they were, trying some stuff in the court and, things were going back and forth and then they took a recess or whatever. And the judge came back out into the room and he had his collar open, so, like he's no longer in uniform type of thing. And he's looking at the guy saying, hey, I'm just the facilitator. Right? So if that's, if he was truthfully saying what he was, then they were already in some alternative dispute resolution and didn't know it. But there was a facilitator. So the president shall designate an agency or designate or establish an interagency committee to facilitate and encourage agency use of dispute resolution under this chapter. Such agency or interagency committee in consultation with appropriate federal agencies, yada, 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 shall encourage and facilitate agency use of alternative means of dispute. Develop procedures that permit agencies to obtain services of neutrals at an expedited basis. An agency may use the services of one or more employee of the agencies. So, in Jackie's case, did I close her court case? Maybe I already closed it. No, it's over here. So in Jackie's court case, right, since, supposed to be the Department of Agriculture, we need to find the neutral that's working for the Department of Agriculture and, send a complaint to them. Say you guys never signed a contract. Because if you go to your closing agent, whoever has all the paperwork for your loan, and say, hey, I want a copy of my loan paperwork back, when they send it to you, there'll be some sort of uniform application for residential loan or whatever the hell they call it. And it's on there. There's a spot on there for somebody from the bank or whoever to sign. And the copy they send you saying that this is what they have is blank, which means the bank didn't sign it. You don't have a contract. So why are you paying the damn bill? Right? So, but in her case, it's the United States that's suing her, so she needs to go to, we need to go find this damn, what do they call it? Neutral. And my guess of where we're going to find these neutrals is, let's see, where were they? In these federal executive boards. Right? Now, these federal executive boards, they have a particular reason for being. They're kind of spread out all over the country. Right? So here they all are, board locations. Right? Federal Executive Board. You might want to write that down. The Federal Executive Boards, established by presidential directive in 1961, are a forum for communication and collaboration among federal agencies outside of Washington, D.C. The need for effective coordination among the field activities of the federal departments and agencies was then and is still very clear. Approximately 85% of all federal employees work outside the national capital region. Federal programs have their impact largely through the actions of field representatives of the departments and agencies. Right? So you think about it, we're never really dealing with the agency heads. We're dealing with, representatives. Well, if we have a dispute, we need someplace to take it. Federal representatives are the principal contact of the federal government for the citizens of the United States. The national network of 20 FEPs located in areas of significant federal population serves as the cornerstone for strategic partnership in the government. I'm just saying, hey, I bet you this is the place where they have these interagency neutrals. And we're going to find out one way or the other. Okay. Okay, so here's an example of a residential offer to purchase, or whatever they want to call it, from however your state handles residential purchases, right? Between a buyer, right? The buyer. Well, that should be, if you're the buyer, you and your full legal name, Robert Allen Retluski, right? If you're married, your name, full legal name, and your wife's full legal name. Or husband's full legal name, however it works. And well, that's who the buyer should be. Then there's a seller, of course. Let's get down here and look at a few things then. What happens in a default? Now, the seller and the buyer are each being represented by agents, right? So even though we're saying seller and buyer, this is between the two agents until the deal's done and they hand it over to you, right? These are, to me, things the agents need to be responsible for. They each have a legal duty to use good faith and due diligence in completing the terms and conditions of this offer. A material failure to perform any obligation under this offer is a default in which may subject the defaulting parties to liability for damages and other legal proceedings. If the buyer defaults, the seller may, right, sue, terminate. If the seller defaults, the buyer may sue, terminate. In addition, the parties may seek any other remedies available in law or equity. Well, that would be arbitration. The parties understand that the availability of any judicial remedy, right? Now, this is judicial proceeding, not administrative, right? Any judicial remedy will depend on the circumstances of the situation and the discretion of the courts. And I can tell you what that discretion of the courts means, because I've had a chief judge of a court tell me Well, it's not that you're not correct. In other words, I was correct. But she was not inclined to issue any warrants. She was using her discretion. Right? So that you don't want that, you don't want the courts to have discretion. But this says that judicial remedies, the court has discretion. So if either party defaults, the parties may renegotiate the offer or seek non-judicial dispute resolution instead of the remedies outlined above. By agreeing to binding arbitration, the parties may lose the right to litigate in court of law those disputes covered by the arbitration agreement. And so, right, it says in there that you can go use ADR. It doesn't say you have to use arbitration, but you can use non-judicial dispute. So, how can the seller default? Well, here's how it happens, right? What's the evidence? Title evidence. Conveyance of title. Title evidence. The seller shall give evidence of title in the form of the owner's policy of title. So this thing here, this owner's policy of title, although this is for Florida, I'm using that as the example, right, is the thing that's supposed to be the evidence of title. Right? Well, the seller is supposed to give evidence of title in the form of the owner's policy of title insurance in the amount of the purchase price of the current ALTA form issued by the insurance insurer licensed to write title insurance in Wisconsin. Seller shall pay all cost of providing title evidence to buyer. It's the seller's duty to provide the evidence to the buyer. Well, if the seller gets a policy that has as the insured, right, this fictitious name, well, then the seller didn't do what they were supposed to because that isn't the buyer. Right? This name now would have to be on the on this residential agreement. Let's see, what else? The buyer shall pay all costs of providing title evidence required by buyer's lender. Okay, so the buyer then, because this is what the buyer does, the buyer paid for title insurance, because that's the evidence, right? What's title evidence? Insurance. By the buyer's lender, because they have a lender's policy of title insurance. So if the buyer paid, and this is on the closing statements, that it shows you paid for the lender's title insurance, and that the seller paid for your title insurance, well, we got a problem. Why are you being taken to court to say you didn't, by the lender? The lender got paid by the title insurance. Well, it's because you're not insured on the title insurance, right? And that's the problem with the seller. Fault of the seller. They defaulted. What do you do in a default? Well, according to this, you go ask for arbitration. Or here's all your choices, right? But you need to be complaining about the proper thing, and the proper thing is that the seller did not provide you evidence of title, or however they word it in your state, because these aren't all worded the same, unfortunately. But somewhere in your purchase agreement, it'll be what's the evidence of title, and it'll talk about you getting title insurance from the seller and so forth. And once you find that, and you find your policy and say, well, that isn't my name on there, well, then you can say that the seller defaulted, and since your buyer's broker was, acting as you, then it's his fault. He needs to go get it fixed. And you can take him to arbitration. And you can take the FDIC to arbitration, and you can take, Fannie Mae or Freddie Mac, whatever form it is you filled out, that when you get your copy from who's ever holding all the papers now, and you see that it hasn't been signed by anybody, then how come they're trying to enforce a frickin' a loan that didn't happen? Make it the United States' fault. Okay. right, hang on just a minute. Okay, so that was just kind of an idea or example of, you're at the end in a foreclosure against the United States for something that didn't happen, and the evidence of it was way at the beginning where the transaction first took place. Well, we have the same problem as veterans because the problem started at the beginning. And I don't know how it works for commissioned officers, but this is for the enlistees, right? Retirement documents, re-enlistment document, Armed Forces of the United States. This would be your DD Form 4/1. Right, and this is the one where you're going to swear eventually. We don't need to get there yet. But it says in here in number 9, for all enlistees or re-enlistees, I understand that many laws, regulations, military customs will govern my conduct and require me to do things under this agreement that a civilian does not have to do. I also understand that various laws, some of which are listed in this agreement, directly affect this re-enlistment agreement. Some examples of how existing laws may affect this agreement are explained in paragraph 10 and 11. I understand that I cannot change these laws, but that Congress may change these laws or pass new laws at any time that may affect this agreement, and that I will be subject to those laws and any changes they make to this agreement. I further understand that my enlistment is more than an employment agreement. It affects a change in status from civilian to military member of the armed forces. As a member of the armed forces of the United States, I will be, right? So you're no longer a civilian. Once you've signed this, took the oath, you're now a member of the military, right? You're going to be required to obey all orders, subject to separation during the end, at the end of an enlistment, if my behavior fails to meet acceptable standards. I may be discharged and given a certificate of less than honorable service, which may hurt my future opportunities and claim for veterans benefits. Subject to the military justice system, which means, among other things, I may be tried by military court-martial. So if you're going to court now as a veteran, right, you should tell them you demand trial by court-martial because you're still in the military. You don't have to put up with that shit. You got to take me to the post. Trial by court-martial. Require upon order to serve in combat or other hazardous situation. And number 5, entitled to receive pay, allowances, and other benefits as provided by law and regulation. Well, I'm saying if they haven't released me from the military, then I'm still entitled to pay allowances and other benefits, such as the damn ID card that you can't get now because the DEERS system is messed up and they're trying to give you a veterans card. But you should be able to get an ID card that looks very much like the ID card you had while you were in. And it will say on it, United States Armed Forces Geneva Convention Identification Card, because you are still in the military. And they have those cards for reserves and retirees. Or they need to give you a separation order that says we're separating you from custody and control of the Army and see you later. But they haven't done that yet. And anyways, you can go read these things yourself. You read 10 U.S.C. 506, it says that, they can keep you in for the duration of the war for 6 months after its end. Well, we're always at war. In a time of war, my enlistment may be extended without my consent for the duration of the war. They can't make it any plainer than that. So my contention is, well, if you've not given me an order that says I'm discharged, and you can't prove that there is an order that I was discharged, then I'm still in the military, and according to your rules, da-da-da-da-da. And so, these are all these other parts apply to it also, and how they can keep you longer and keep you in. And, well, what does that mean for you? For me, I served 8 years in active duty. They didn't release me, so I continued on in the reserves, and I'm due a retirement from the military. But also, because you're still in the military, even though you're, on some kind of inactive reserve status, If you go to the VA and they say you're 50% disabled from some, um, from military, your service in the military, well, because you're still serving in the military, you should get retirement pay, disability retirement pay, and pay from the VA. And it says so in this, they say so, Defense, Finance, and Accounting Services. Your disability percentage, right, qualifying for disability retirement. This isn't from the VA, this is from the DOD. Right? I'm saying I'm still in the military. If the VA gives me a percentage and say, well, this is because of your service, and it's high enough, I should be able to go to the military and say, hey, you got to retire me. I believe they've already done that, and I'll show you why, but this is just proof of the fact that it can be done. Your disability percentage, which will be assigned by the Physical Evaluation Board, will determine whether your disability qualifies you for retirement or separation. But either way, if you've been disabled, you're going to get retirement or separation pay. If you have less than 20 years of active service, not active duty, active service, which would include being in the reserves, even if, inactive, a disability rating of 30% or higher will qualify you for retirement, and a disability rating below 30% result in separation. If you have more than 20 years of service, retirement will be recommended regardless of your disability. So if you have a disability and you say, hey, Army, I'm disabled now, I'd like to, claim my disability retirement, they'd have to give it to you. Your branch of service may place you on either a temporary disability retired list or a permanent disability retired list. My DD-214 says they've done this. A member on these lists is retired member of the armed forces. You are entitled to all rights and privileges of a military retiree, which may include participation in survivor benefit plans, voluntary and involuntary allotments, and disability compensation from the Department of Veterans Affairs. You can collect both the retirement from the military and disability compensation from the Department of Veterans Affairs. Now, if you go and look at this military retirement fund, if you Google that, you'll find this audit here. And I've done videos on this before. And in this audit, it shows, I don't want to go through it, takes too long to find all these parts, but it shows in there that the military retirement fund itself has almost $1 trillion with a T, trillion dollars in it. But they're only paying out like $50 billion a year, which is less, and that number itself is less than what Congress gives them to cover retirement. So where's the other retirement money? Because Congress wouldn't give them more money than they need to cover the retirement. Right? Somehow the rest of us have deferred our retirement pay and it's going into this fund. Because brothers and sisters, we've been retired. They've done something to us. So, here's some simple proof. Here's a DD-214 for Dana Reed Smith. And in his case, you go down here and it says transferred to Naval Reserve. It doesn't say that he was kicked out of the military. He wasn't released from the custody and control of the Navy. No, he was certificate of release or discharge from active duty. That's all this DD-214 does. It says you're no longer on active duty. Okay, well, my DD-214, in this Block 9, it has an NA. And if you go look up the reasons for an NA in Block 9, and this is Army Regulation 635-5, we'll look at the cover in a minute. Right? They have a table in here, DD-214, item 9 entry determinations. I'm sure this is the same for all branches, right? But this is the Army's. Okay, well, why could there be an NA? Well, one reason is there's no further military status. NA. Okay, where's the order? right? That would mean that I was no longer under the custody and control of the Army. But I'd have to have an order that said that. Otherwise, the reasons for an NA are I was placed on a retired list and not transfer the retired reserve applicable to RA enlisted with 30 or more years AFS, or USA retired list applicable to RA officers, or TDRL, or permanent disability list. Right? So I'm not an officer, so this one about officers doesn't apply. I guess I could be this one here, and this is the Army of the United States retired list, the AUS list, and not transferred to the retired reserves for whatever reason, or I was put on the TDRL or the permanent disability list, or that's for retirement, or release of retirees serving on active duty and retired status. I think this is what most retirees do. They serve on active duty and retired status. Right? Release from retiree serving on active duty and retired status. Right now, if you're retired, you're still serving on active status. That'd be another reason for an NA. But, either you're on a retired list for an NA or you were booted out of the military. Well, I don't have any orders showing I was booted out. So that's my, this is the gist of my complaint I'm going to file for my alternative dispute resolution. So, okay, I got to look at a couple of items to get them lined up here. Okay, I should go on and say that, like on my DD-214, there's all sorts of errors. I didn't sign it, so it was signed in absentia, which means, was I AWOL? Was I missing in action? Was I in the hospital? Why didn't I do it? And I didn't have this dental care. And everybody that I've seen that has this box, right? Now in the new forms, they actually have a box where they just check yes or no, right? But did not receive within 90 days. Well, that's a big deal because that means that they could keep you because you haven't had your final exam yet. Right? Medically, they could keep you in the military because you are waiting on treatment or something. And I have a separation code of JBK, which comes from a manual that we'll look at. Well, we'll look at it right now. Here's the manual, JBK, right? This is 635-5-1. Separation code, separation program designators. JBK. Where are you? This may be is this one for officers? Officer personnel. Gotta go down a little lower. Enlisted personnel, JBK. Right? Completion of required active service. Now, if we were to read all the fine print in this, you would find out that it says whatever code you pick, you need to use the narrative exactly as you see it when you put it on the DD-214. Otherwise, it wasn't done right. Okay, and on my DD-214, it doesn't say completion of required active service. It says expiration of term of service. So, it's an intentional error put into the record. Like saying I wasn't there to sign it. That'd be intentional because, I was there. They didn't call me in or whatever, and I didn't sign it, but so be it. And this JBK, when you go look at this damn thing here, it's got these notes that go with it, right? That I'm going to be discharged per 635-200, Chapter 4. That's administrative separations, and it has Note 7 tied to it. You go down here and look at Note 7, except for those with a DCSS in force, whatever that is, to be used for RA soldiers ineligible for or barred from or otherwise denied reenlistment that are separated on completion of enlistment. Well, so they're saying I couldn't reenlist. As soon as I'm separated, I can't reenlist. But this reenlistment code, RE1A, says I can reenlist. So there's just all these little errors, right? Boom, 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 all over on this document. But the one I'm going to go with, well, you have NA up here and I say that means I was retired and you haven't paid me my retirement pay. Okay, so that's that. I want to go back though, because there's another form that you fill out when you first go into the military, right? For everybody, think about this. You're talking about 18, 19-year-olds going to go fill out some paperwork that's been lawyered up, right? So yeah, you may be signing things and not really know what you're doing when you're signing these things. Like they want your personal data, and they ask for your name, and then they put in parentheses last, first, middle, right? But if that was the case, they could have put a block that said last name, and then a block for first name, and then a block for middle name. That they didn't. They just put name. Well, your name isn't last, first, middle. Your name is first, middle, last, or given last, right? So Robert Allen Retluski should have gone in this box. But of course, I did what they said, I'm sure, and put in Retluski, comma, Robert Allen. Which is why that's the way it shows up in the damn DD-214, right? Because I told them that was my name. Okay, so hey, there's an error, right? So I don't want to have a court case about it. I just say, hey, there's an error. I'd like to go back and fix my records. And I'm going to have to go into that deeper on another video, but they show all these ways to do this, and that's your duty to do these things, to go back and look at your records and make sure they're correct, and they give the proper way to do it, and, we're not. So anyways, you got all these blocks you're filling out, and this is doing the aptitude test results. So this can't be at the recruiter's office when you first went to them. This has to be after you went to the MEP station. So probably prior to taking your oath of office, but just prior to. So I don't know what you fill out at the recruiter station, what other documents there are. I can't get all the documents, or I haven't found them yet, but there's stuff going on. And on this form, though, if you go here, this is good, right? This form is the DD form 1966. And I'm sure if you enlisted, you filled one of these out. And if you go to these things here, this will take you to the information. I might as well just do it since I'm here. That has to do with this series of records, right, that are incorporated, or that this document's going to be incorporated into. And in here, it tells you how to authority for the maintenance, policies, retention, notification procedure. Individuals seeking access to records about themselves contained in the system should address written inquiries to the commander of the organization to which the service member is assigned. For retired or non-unit service personnel, information may be obtained from the U.S. Army Human Resources Command, Spearhead Division, Fort Knox, Kentucky. For discharged or deceased personnel information, contact the National Personal Records Center. So I'm going to contact both of them, right? Because, hey, it's just 50 cents. I'm going to send them both, see what they got on me. But this is how you get those records. That's all I really wanted to show without getting too deep into this. This would allow you then to go find your records and get a copy to see, and then ask for all the records that are in that set. So anyways, now we're going to get sneaky, because up here they had you put first, middle, last. All right? Last name, first name, middle name. Didn't say middle initial, said middle name. Well, we're about to change that. We're going to go to page 2. We're going to have you put your name in, first name, middle name, or last name, first name, middle initial. So you just changed who you were, right? Because you did what was in the fucking parentheses. And now you're going to certify, right? Last, first, middle initial. I certify that the information given by me on this document true, complete, and correct. Well, you just committed perjury. Now, you were coerced into it, but you did. See right here. you're going to certify under last, first, middle, initial, and then sign it. So they're changing who you are on this damn document. You just lost your middle name. It's going to be certified by a witness. Certification recruiter or acceptor. Certified. Got witnesses that said your name was Ritluski, Robert A. And there are records where that shows up that way. Right? So for those records, they're only using this page. They only want this information. But for other records, maybe they're using this page up here, like your DD-214, right? Where it's going to have your name backwards. So there's, errors in records. We don't have a separation agreement or contract or, separation order, I guess the proper word. So we're still in. So I'm going to say, hey, I have a situation I need to deal with the military. Release from custody and control. Okay, this is the one that has, I can go down to 4. Because this is the one where I'm supposed to be discharged based on a certain chapter in this manual. Hang on here. What was that about that? Discharged in absentia, because that's what they did to me. Except as provided in 312, a soldier placed on excess leave without pay pending completion of appellate review may be discharged without returning to military installation when sentence is affirmed. Right? So did they discharge me in absentia? I don't know. Now, Bob from Pennsylvania said that his dad's DD-214 from the Korean War, it says on his that he was put on leave. Right, so he's just been on non-paid leave ever since the Korean War. Separation for expiration of service, discharge, release from active duty upon termination of enlistment and other periods of active duty or active duty of training. But yeah, I was discharged from released from active duty. I was discharged from active duty, but not released. And I had in here this one little section in here that, Title 10, USC 3914, soldier on area must be on active duty at time of application for retirement, and at time of retirement, there is no statutory requirement. So basically, are we still in the military, and we need to be put on active duty so we can retire and go back? Because right now we're in the reserves, right? So you go back for a one-day contract to retire. Soldier precluded from reenlistment. So this is my problem because, the other note said that I couldn't reenlist. So soldiers precluded from reenlistment for any reason and discharge forfeit retirement eligibility altogether, and reentry on active duty for the purpose of applying for retirement is not allowed. Right? So, you could re-enter active duty to apply for retirement. But if if that's why you were told you can't do it, or why you're being released, then they won't let you do it. And that's what it was showing on my other form there, that right, go to this JBK and look at its notes, and accept if I have that in forced, then to be used for RA soldiers ineligible for, barred from, or otherwise denied enlistment that are separated on completion of an enlistment. Well, right next to it, it says I can be enlisted still. RE1A. Okay. So I'm going to go to the Army and talk to them. And as it turns out, hey, the Army had a mediation handbook. Practical guide for using mediation to resolve workplace disputes. And we won't look at much of this, but just to give you an idea how they're supposed to work. Where are you? Where are you? Where are you? So here's the ADR continuum, right? That you got from informal to formal, and they all fall on a line. And you got negotiation is the least informal, facilitation is slightly more formal, mediation is again more formal, but it's still informal compared to formal, which starts over here at early neutral evaluation. Oh, parties retain control over the process. That's on this side. And parties cede control of the process. That's over here. So early neutral evaluation, settlement, conference, or summary, jury, trial. Well, that's what I want. I want this guy to make a settlement conference. I have him look at, what I'm telling him and say, according to this, I'm still in the military. You're going to have to agree with me. And if he does, then as the neutral, he can push the envelope and get me my settlement from the military that I can't seem to get directly. But after that's arbitration and then litigation, and that's how they have it listed in their thing. Right? The second principle, neutrality, means the impartiality of a mediator. So then I talked about these different kinds that they have, and that two federal statutes form the legal basis of mediation and other ADR procedures in the federal secular workplace, which would be the military. The first is that act from 1996, which is ADRA. All right, that's for administrative disputes, which is what we're trying to do. And the other one is this one from 1998, which is for litigation in judicial courts. Right? Because each district court has an ADR program consisting almost exclusively of mediation. But it's going to be done under this act, not done under this act. And so I'm not going to try to go to the court. I'm going to try to go to the neutral. Act as a dispute resolution option, blankets workplace disputes from initial administrative claim to lawsuits. Well, good enough. Regulatory and policy authorities, right? You can Google this DOD manual and find it, and it just goes on and on and on, gives more examples of ADR, right? So how do you do it? It wants you to go follow this Army regulation here for these discrimination complaints. And then they find out that they have negotiated grievances, which are for the bargaining unit employees, right? People in a union. But then they have administrative grievances for people that are a non-bargaining unit employee. That would be the military. You're not in the union, but you were still an employee of the federal government. So we should be all file administrative grievances. And so there's more to read on this. But what I have done so far then, having looked at all this, and I just like to say, well, I know enough to throw something against the wall. Let's see how they respond. Is I sent something to the Office of the Army General Counsel, right? Because they're the ones for the Army. Come on now. Office of General Counsel of the Army. ADR. Read a little bit about it. Blah, blah, blah. Okay, sounds good. How about contact? Contact for ADR. They had an email address. Good enough. And then, hey, they had another email address down here. Well, shit, I'll just send it to both of them. So that's what I did, and I sent them a little complaint to Well, to get started. So the director is Mark Van Nuys. Enlistment agreement grievance, Ritluski, Robert Allen, Social Security number 374506794, date of birth 580905. Director Van Nuys, I am the real party in interest to a specific enlistment agreement, a DD Form 4, with the United States Army, by which I am entitled to receive pay, allowances, and other benefits as provided by law and regulation. Unfortunately, a lack of communication between the United States Army headquarters and myself, and a number of administrative errors in official records caused by the federal government or its employees, has resulted in my entitled pay, allowances, and benefits being unjustly withheld. The state of affairs causing this injustice is clearly a mistake, and I am of the belief that my United States Army will inquire into the matter, correct mistakes, issue orders, and provide me my back pay, allowances, and benefits as agreed to by the United States Army's acceptance of my oath of enlistment. I have attached a copy of my DD-214 for your review, because on your oath of enlistment, I mean, that's the nice thing on all these documents, the military is signing. Enlistment, re-enlistment officer certification, right? So you have an agreement between the parties. And if somebody, hatched a scheme to make you commit perjury, well, it's not your fault. Just go say, hey, there's an error on the records. I really didn't agree to this. I was 18 at the time. Right? I'm honorably discharged veteran. Here's my, discharge. Right? Just discharged from active duty for honorable and faithful service. Okay, there are administrative errors on records used to populate the fields of my DD-214 and in my Defense Enrollment Eligibility Reporting System, DEERS record. So all veterans, you have this DEERS record also. And like the errors in mine, it has my name, Ritluski, Robert A., and it has my birth date as the 1st of September, not the 5th of September. And then it may have other ones, but those are the ones I can see. And they won't let you look at the damn record. So, who knows what else is in there. Okay, so causing a controversy regarding the pay, allowances, and benefits due me to include the acquiring of a DD Form 2S United States Armed Forces Geneva Convention Identification Card. Not the inferior DD Form 2, because there is a DD Form 2, but it's a 2S. The 2S is the one that says United States Armed Forces on the top, Geneva Convention Identification Card on the bottom of the front of the card. At least that's how they show it in the examples online. So the NA, it wasn't in /A, it was just NA. In the block 9 of my DD-214 indicates that I went and found that section in that manual and put it in there. AUS retired list, not transferred retired reserve, or USA retired list, or TDRL, or permanent disability. Army Regulation 635.5, separation documents. I did not sign my DD-214. I did not receive a DD-215, which is supposed to be what happens if you don't finish up the 14. I did not receive required continued health care, and the narrative given in Block 28 is not the narrative designated by regulation for separation code JBK in Block 26. In other words, they didn't, go to the manual, say, here's the code, here's the narrative. They made up their own. This code is incompatible with the use reenlistment code RE1A, Block 28. Even my DEERS record incorrectly has my name as Ritluski, Robert A., and my date of birth is 09/01/1958. I received no separation pay, and no administrative separation order is ever issued separating me from the custody and control of the Army in accordance with Army Regulation 635-200 or any other regulation. And I remain to this day a soldier in the United States Army and expect the Army to acknowledge the same. My enlistment agreement states, laws and regulations that govern military personnel may change without notice to me. Such changes may affect my status, pay, allowances, benefits, and responsibilities as a member of the armed forces, regardless of the provisions of this enlistment contract or document, I think they call it. As I was not noticed of any changes and did not receive separation pay or administrative separation order, only God, country, and the Army can know my current status and know that administrative errors resulted in entitled pay, allowances, and other benefits being withheld from me. Whether conscious or not, the Army has defaulted on this enlistment agreement, and God and I are in expectation that the Army righting this wrong and fulfilling this obligation to enlisted soldiers. Please let me know how ADR can resolve this issue. Take notice, every enlisted soldier has the same claim. May your conscience be your guide. I sent it out just before Christmas. And so, that isn't going to the neutral, right, like at these FEB boards, but they'll be next. There's an FEB board right here. All right, these FEB boards, they have these locations. As it turns out, there's one in Detroit. And the one in Detroit. More info. All right, gives you the website, although it doesn't open for some reason, and it gives you a point of contact. Michelle Rhodes, GSA.gov, right? She's not DOD, so she could be an arbitrary or a neutral. I don't know where these people are from. Well, that's her. She's the executive director. Right, so I'm going to say she's a good candidate to be the neutral. So I'll write to her and give her the same thing that I've already given the Army and see what their answer is. Okay, well, that's really all I wanted to show was, that I didn't really talk about the veteran side, but the veterans also have alternative dispute resolution. And so, well, I did do something with them. Give me just a second. I want to show you. I might as well get them all done. Hang on. Okay, I had found this on probably the VA website. Free legal clinics in VA facilities. Right, so just Google that. Free legal clinics in VA facilities, and there's this 18-page PDF, and it lists all these different states and facilities and if they have somebody or not, how it works. The VA contacts listed below are not attorneys, and therefore incoming email is not attorney-client privilege nor a secure form of communications. Good, I want everybody to know about it. Now, unfortunately, my guy is an attorney. I looked him up. So there is something here we'll have to see what they're talking about. These VA contacts can provide additional information about the legal clinics operating in their facilities, but cannot give legal advice, determine your eligibility for legal clinic, schedule legal clinic appointments for you. Okay, well, what can they do? I don't know, but I went down to Michigan and I found, every state's listed in here. Michigan, Michigan, Michigan. Hey, John Koch. Koch? K-O-C-H. Did I say Koch? All right, Legal Aid Organization, Grand Rapids Veterans Bar Association. I had an email address, so I emailed John. And he had to say to me, so basically I said, Mr. Koch, Mr. Koch, numerous administrative errors, my DD-214, defense enrollment at DEER's record, are causing an unjust denial of benefits, privileges, allowances of pay I am entitled to by contractual agreement with the United States Army. I do not want to sue the United States Army or the Department of Veterans Affairs. Instead, I would like to utilize the ADR programs of the Army and the VA to expedite their agreement to my claims, and they're providing a speedy remedy. The Army and I signed a DD-214 or DD-4 enlistment document. Yada, yada, yada. DD-214 evidences I was discharged from active duty, not separated from the Army. I never received an administrative order. releasing me from custody and control of the Army, and I am to this day in the Army required to have a United States Armed Forces Geneva Convention identification card. We enlisted veterans are in the United States Armed Forces, and the services have to acknowledge our status of in and issue our military IDs. It was the Army's decision to retain me in the Army, and because the Army did retain me, then I am entitled to receive pay, allowances, and other benefits as provided by law and regulation. Veteran Administration has my name as Rutluski Robert A. and date of birth is September 1st, 1958, and my DEERS record, right? Because I go to the VA site to log in, that's where these errors are. And they have refused to correct these errors. I've tried a couple times, said, you guys got it wrong. It's, Robert Allen Rutluski. Now they have Robert Allen Rutluski. Name of the member, Rutluski, Robert A. Date of birth, September 1st, 1958. I mean, that's what's in my frickin' VA record. From the very first paper signed by a recruit, administrative errors begin to appear in official records, and as long as these errors are in the records, we veterans will be unjustly denied entitlements. This kind of crap is done to all veterans and has to stop. So can you help me use the ADR system of the Army and VA to get their agreement to fix administrative errors and provide equitable relief? If so, please advise. And he answered me the next morning and says, it appears from your message, you're beyond seeking legal advice, but I'm not, and are looking for representation. Well, not yet. I'm looking for legal advice. I may be looking for representation, but I'm still looking for legal advice. John. The Veterans Legal Assistance Clinic provides volunteer attorneys and law students to provide legal advice and potential resources. All right, so he's telling me what they can do, but he's trying to get me to go to this Kent County thing. Like, those aren't the things I'm asking for. Right, so however, through the Kent County Veterans Service Office, there is a retired veteran attorney who is interested in taking pro bono, low bono cases for veterans involved benefits. Your description of your situation is unique, so I cannot guarantee that this would be one that would be accepted, but it's worth exploring. The avenue with which to approach through is through the Kent County Veterans Service Office. The other avenue is to seek legal representation through the Michigan Bar Association referrals system. So it isn't that it's, not good information. It just isn't necessarily perfectly good information. Because I'm really looking for legal advice. I want to know, how do I file my grievance into the Army or the VA, into their ADR system, into the lowest possible level of, disagreement, to get their agreement, have them fix the records, and be done. Like, I don't want to even do arbitration. So, again, I'm thinking this through these neutrals that they have. That's why I need to get back to John. Well, John, who's the neutral for the VA? Right? I want to know, how is the VA's ADR system set up, and how are they applying with the policy that the Act from 1966 and da-da-da-da-da. And so, but hey, he was nice enough to write back, and he's not wrong. There is a retired veteran attorney who is interested in taking pro bono for low bono cases. Okay, well, excellent. If you'll take it for the fees, then you can do it. Because we're going to go after the United States as being the respondent. I don't want to say they're the defendant, because this is non-judicial. They're just like the respondent. And if they agree, well, fines. But whatever hours the guy had to put in to get their agreement, he can be paid because of Equal Access to Justice Act. So it'll be an interesting week once we get past the first of the year. And can't hardly wait. Okay, I'm going to leave it there, but I'm going to ask one more time, if you're still watching, if you would please donate. Call it charity, pay it forward. Because truly, I can't pay my rent, which is due in 3 days. And I'm quite a ways behind paying my rent. Please help. Very good. You all have a great day, and I hope you found it useful. We'll see what happens next. Whoop, come on now.